Now, Kaylee's asked in the group, we have registered our relationship in birthdays and marriages in Victoria. Is that the same registration as a civil union? Will this rule out the 12-month rule? Kaylee, every state and territory has their own, I suppose, equivalent to a civil union that will be recognized for the waiver of the 12-month rule. So you'll have to check with the state specifically to confirm that that is the appropriate registration type. But I can say that registering the right type of relationship in Victoria will waive the 12-month rule. So I can't say necessarily in terms of what you've mentioned, whether or not that will waive the 12-month rule. We'd have to have a look at what the certificate is, what you've specifically registered for, and double check that that falls within the correct type of registration in the state that's recognized for the 12-month rule waiver. So we'll continue on. Now, Olga's asked, hi Martin, I have a question regarding the Bridging Visa B. If I plan to travel, but I don't know when it will be possible, do I need to apply now? I just got my Bridging Visa A. Is the Bridging Visa B granted for a year or so, or just for certain timeframes of the upcoming trip? Okay, so Olga, I think for this one, we might go to my trusty whiteboard and we will draw this one out, okay? So you are inside Australia on your Bridging Visa A from what you mentioned. I'm going to assume that you are on the Bridging Visa A and that your previous visa has expired. I'll talk about both scenarios, so just rest assured, even if this isn't your specific scenario, I'll talk about the alternative in a second. But if you or anyone is on a Bridging Visa A having applied for an onshore partner visa, let's say, and you're looking to travel, you can apply for your Bridging Visa B. And we find the Bridging Visa Bs for those that are waiting for onshore partner visas are being granted for 12 months. Okay, so normally Bridging Visa Bs are granted for 3 months, but that is, discretionary. You can request longer periods, but we find that it seems to be the case that the department, without needing to request specifically any longer length of time than 3 months, onshore A20 visa applicants who apply for Bridging Visa Bs will get 12 months. So if that's the case, the BVB allows the visa holder to depart the country and they have to be back in before the expiration of the Bridging Visa B. The BVB is the door or the ticket that allows them back in. However, I have to say that this is all, pre-COVID and pre-travel bans. Before COVID, and before the travel bans were put in place, that was a very common scenario, a very common sequence of events. The issue now, though, is that if you depart the country, the BVB is not a right to re-enter. You need to separately apply for permission to enter, permission to travel. And unfortunately, this decision is completely discretionary and very inconsistent. So we're finding a lot of mixed reports in terms of who actually is being granted permission to travel, particularly in the context of partners of Australians. And we are hearing that typically married couples are the ones that are being permitted to enter. De facto couples seem to be running into more problems. Now, I have to say, we don't prepare these permission to travel applications simply because of the uncertainty around who's going to be granted permission to travel and who isn't. And we just don't like to charge our clients for a service unless we feel that we can give them a certain level of guarantee or certainty that what they're paying for will lead to an outcome, will lead to a positive outcome. So for that reason, we just don't prepare these applications. However, of course, we do keep our eye on statistics and we speak to other colleagues and other friends in the industry. And the general consensus seems to be that those that are married seem to have a higher chance of being granted permission to travel. So it's not an issue of the Bridging Visa B, it's the issue of being able to come back in. So like I said, that in pre-COVID, that would not be a problem, but we have to obviously talk about these things in the context of COVID and the travel bans that are in place at the moment. So that illustration was for those that were on their Bridging Visa A's. Now, the second common scenario, and again, I'm going to talk about this in the context of pre-COVID. There's the scenario where someone might be in the country on their visa, on their substantive visa. Now that's most likely going to be a working holiday visa, or it's going to be a student visa, or it's going to be some type of visitor visa. You know, those I suppose would be the three most common. And you know, they've applied for their 820 and their bridging visa A has been granted. Now, just because they were granted their bridging visa A doesn't mean it's in effect. It stays in the background because they still have these substantive visas. So again, pre-COVID, if someone in this scenario was looking to travel, depending on when their return date was, would determine whether or not they needed to or should apply for a bridging visa B before they leave. For example, if you're here on a working holiday visa, again pre-COVID, and you depart the country, you can re-enter within the validity period of your working holiday visa. So, you know, today is the 18th of June. And let's say you have a working holiday visa until 18th of December, 2020, and you're looking to depart the country and come back in before this date. Now, you don't need to apply for a bridging visa B because you have a valid visa that gives you the permission to enter. You have a visa that has a right of entry into Australia, so there's no need for the BBB. If, however, and same applies for student visa holders and visitor visa holders, if, however, you're looking to re-enter the country after the expiration of your visa, in that scenario, yes, you would apply for the bridging visa B, even though you're not on the BVA, because you need the bridging visa B to kick in at this point, and that's what allows you to come back in after the expiration of your visa. You come back in on your BBB. So in simple language, the BBB kicks in whilst you're overseas, because whilst you're overseas, your substantive visa has expired, your BBB comes into effect, and then you re-enter on the BBB. So that's the second common scenario for partner visa applicants or those that are looking to apply for partner visas, and they're asking questions around when do I need to apply for a BBB? Do I need to apply for a BBB? Those are really the two most common scenarios. I hope that answers that question, Olga. Let me know if it is unclear. Now, there were some questions asked earlier this morning that I answered in text, so I'm not sure there's any need necessarily to go back over them. If anything jumps out as interesting, I will. I've got one here from Marika, so I'll just put her question on the screen. Marika's asked, hello, I have a few questions regarding the Form 888s. I've tried to search for the answer, but I could not find it. Do they have to be signed? Date on the Form 888 before the date I lodge the application. I have the details of my witnesses, the 3 Australian citizens, in the application itself, but I want to know if I have to wait until I receive the forms finally signed and then lodge, or if any new forms can be added after any time after lodgement, even if I didn't mention them in the application. I just realized I can ask my family overseas who visited us here and can get them to certify these forms in their country, but it'd take a little bit longer to get those. Okay, so Marika, let's work through your questions because there's a few sub-questions there. Now, your first question was, do the Form 888s need to be signed before the date of application? The answer to that question is no. There's no need for the Form 888s to be, sorry, Manuel, I need to take you off my screen for a second. There's no need for the Form 888s to be dated prior to application. I understand why you're asking, because in the actual IMI application form, so in the visa application form, it asks you for details of 2 witnesses. So you're concerned that you're providing the details of the witnesses on the application form, but you don't have the corresponding Form 888s. I believe that's what you're referring to. That's not a problem. You can provide Form 888s at any point after lodgement. It doesn't matter if they're dated post lodgement. And in fact, it's very common for couples to continue to update their relationship evidence after lodgment. So you also mentioned that you have family overseas and you're looking to get them to write Form 888s, and you're concerned that you won't get them back before you apply. That's fine. You can request the Form 888s from them, and then whenever they're returned, as long as they're completed correctly and their signatures have been witnessed properly, then you just attach it to your application if you've already applied for the visa itself. You may or may not know, we do have a Form 888 swipe file which contains 15 examples of completed Form 888s. You can buy it as an add-on when you purchase our relationship statement guide and template pack. There should be a link somewhere around this video to make those purchases. Okay, Marika, I hope that answered all your questions. I'm just making sure I haven't missed any. Yes, I think those were the three. Do they have to be signed prior to lodgement? No. Can you update the Form 888s, or can you add additional Form 888s after lodgement? Yes. So Rachel has asked, will there be an impact on her partner's current visitor visa or a future partner visa application if he is refused the travel exemption or refused the permission to travel? I have commented on that thread, but I'll just reiterate. No, the applications for the travel permission are not relevant to currently held visas or subsequent visa applications. They are their own unique assessment, and they're not tied into visa criteria later in future. So there's no issue there, Rachel. And really, whenever we receive these types of questions from inquiries and from clients, we say, look, it's worth trying. There's no harm in applying for the travel exemption. But as I said earlier in the stream, we are finding and hearing that the realities around getting the permission to travel are quite stark, and that only a very limited amount of people, and particularly couples that are married, seem to be getting permission to travel. I'm not saying it's impossible, it's extremely variable, but I just want to set realistic expectations. So yes, of course, you can try. No, it's not going to impact his current visa or any future application you make. So Ella has asked, need some advice on how to present evidence such as relationship photos and time apart messaging evidence. I did a one-page PDF document of all relationship photos, clearly labeled, and the same for the time apart messages. Would this work? Yes, yes, there's no issue in merging documents and collating them under one classification. So if you have your photos as one PDF, so all your photos go into the one PDF, and you can call this color photographs of couple. And then you can have another separate PDF that shows your communication with one another. That's meant to be a speech bubble. There's no problem in collating similar documents together and forming one larger document. Just understand that there are size limitations when uploading to the department system. So you have 5 megabyte size limitations. And that typically can be a problem with photos, because if you have, 50 plus photos, each photo will be a certain amount of megabyte each, around there anyway. So the more you merge, the larger the size of the file, the higher likelihood you're probably going to exceed the threshold. So you might have to split documents and attach multiple PDFs that all contain your color photographs. You can just label them accordingly. Color photographs 1, 2, 3, no problem there. You've also asked, Ella, in terms of time apart evidence, other than screenshots of conversations, train tickets and messages to show how a relationship of a sexual nature, there is anything that else I should include? How many messages should I include? As me and my partner have been together for 2.5 years, so there's a lot of messages. Yes, common problem. My answer to that question is that you want to provide a nice collection of your communication with one another. There's no need to provide every message ever sent as a couple. It's just not realistic. So, you have your entire relationship length. So you might have met, you said 2.5 years ago, and you just want to provide a nice collection of your communication for, let's say, every 3-month period. I would focus on providing communication that might be written so that you can provide that to the case officer so they can see what you're writing to each other. So that's one form. There's then also call extracts or call records that you can provide. So your mobile phone statements, you can highlight each other's numbers to show that you've been calling each other. That's a lot less relevant in this day and age now that people use things like WhatsApp, Skype, Messenger to communicate. A long time ago when we used to prepare partner visas, before really all these tools became common, couples would call each other and we would use their phone bills to show their constant communication with one another because text messaging was very expensive. I think 20-50 cents a text message. So we didn't used to rely on text messages as much. Then the evolution happened. Text messages started to take over from phone calls. And now, we're in let's say the new wave, which is using social media platforms to communicate with one another. So like I said, there's no need to provide all of your communication. Just try to provide a summary for each period and try to make sure that you're focusing in on key milestones that maybe you've communicated with your partner. So if you've booked a holiday and you're talking about your holiday in your messages, show that period. If you purchase things together as a couple and you talk about those purchases in your communication, show that to the case officer. So it's just about being logical and selective in what you give them. A case officer is not going to sit there and read through your 2.5 years worth of chat transcripts unless they're looking for a reason to refuse your application.